Hello, everybody.
This is cause number 23 CCCR 1888. Case of Style, State of Texas versus Ryan Paul Barrett. We have Mr. Barrett present in court with his attorney, Attorney Gregory, and we also have the state present with Assistant Attorney Hubel. The court had a bench trial in this case, and I see a trial court certification of defendant's right of appeal, which is dated January 12th of 2024. That was the date that the court found Mr. Barrett guilty. The court did conduct a pre-sentence investigation. Court has received a copy of that pre-sentence investigation. And I think at the hearing that we had a sentencing hearing on February 16th of 2024. If the court did not ask the parties, well, I think the court did ask the parties that they received a copy of the motion, well, a copy of the pre-sentence investigation report. Now, State, is that correct? Did you receive a copy of the pre-sentence investigation report?
At that time, we did, Your Honor.
And do you have any additions, any objections, or do you have any additions or any corrections to?
The second thing that I made at the time that we received them.
Okay, and Mr. Gregory, did you receive a copy of the pre-sentence investigation report?
Yes, Your Honor.
Do you have any objections to or any additions to this pre-sentence investigation report?
I have no additions. I did raise some objections, and I believe the court approved some of those objections back when we had a hearing
Okay,
on that.
okay. And then the court, I guess here, you had filed a motion for reconsideration.
Yes, Your Honor.
Heard that motion, the court denied that motion on February 16th of 2024. And the court reset this case after I think the state put on complaining witness for some punishment evidence. I don't think there was no other witness that the state put on. Is that correct, State?
Yes, only the complaint witness, Your Honor.
Is that correct, Mr. Mayor?
That is correct, Your Honor.
Okay, and then the court reset this case for a sentence on today. And so the court has looked at the case, and so I think the court is going to assess punishment in this case.
Your Honor, if I may, I would like to re-urge the motion to reconsideration. You know, this trial was held in the first part of January. You found him guilty on January the 12th. You referenced a February date at which we were here, and the court considered a pre-sentence report. It was reset to March the 27th, at which time we had argument before the court.
Oh, March, okay.
And at that time, the court couldn't sentence him for whatever reason. Let me suggest this. I came across an explanation that says proof beyond a reasonable doubt is the quote hesitate to act formula in Victor v. Nebraska. The United States Supreme Court approved the following version of this formulation. Quote, reasonable doubt is such doubt as would cause a reasonable and prudent person in one of the graver and more important transactions of life to pause and hesitate before taking the represented facts as true and relying thereupon. Judge, that's what you have done in this case. You found him guilty first part of January, and in February we had a sentencing date, which you put it off into March, and in March you put it off until now. Here we are 5 whole months later. Judge, you have hesitated and paused the exact definition that the United States Supreme Court said this is what reasonable doubt is. Judge, you have reasonable doubt in this case.
Okay.
Already ruled.
Now, Mr. Gregory, I'm sure you're aware that Texas does not have a definition for reasonable doubt.
Yes, I do. This is just argument.
Okay.
This is like a jury argument. I'm arguing
Okay.
to
But
the court. I'm suggesting, Judge, you've got reasonable doubt.
Okay, the
There
court,
was that video, there was no mouth movements, there was no audio that this guy said it, what she said he did.
I looked at the video about 30 to 50 times, and I heard the audio that many times. The court made its ruling the next day. He was found guilty the next day. So you saying reasonable doubt, the court made a ruling the next day. The court did not hesitate to find him guilty. He was found guilty the next day. We had trial. Uh-oh.
I just have to keep urging my client's position.
I understand. But that's,
What
it's,
I feel is prudent under my part.
okay,
And I've made my plea one more time.
okay. Well, again, your motion has been denied. The court is going to assess. Oh, yeah, we have that Amber Alert. Okay, so, his punishment is gonna be assessed at 30 days in Jefferson County Jail. However, the court is going to suspend, that, in that jail time, that confinement time, and he's gonna be placed on probation for 1 year. During the 1 year probationary period, Mr. Barrett will be, ordered to pay a fine of $300 plus court costs. He, will, be required to, attend and complete the batter's intervention prevention class. He will have a curfew from 10 p.m. to 6 a.m. He cannot have any contact. Now, the curfew will not interfere with his, if his job, it's not going to interfere with his job. Now, he cannot have any contact with the complaining witness in this case, Dalen Thornton. They asked him for, yeah, he can't have any contact with the complaining witness in this case. And he also will adhere to the other standard terms and conditions of probation.
You are aware that is his ex-wife and they have 2 children together.
I understand, but it won't, let's see. There's no contact, will not interfere with his, I think they have custody arrangements in a divorce, is that correct?
Now, there's custody action ongoing.
Right, so it shouldn't interfere with that either. I don't know how we can be able to, we should be able to, I think we had he had some bond conditions where we
We had discussed some wording before.
probably use that same bond condition.
What you wrote on bond conditions was not the same thing that you verbalized in court, and it didn't get on with bond conditions that there was going to be some contact allowed.
Okay,
to the children.
Oh, okay, let me do this here. Let me look at the bond conditions, right? Motion to modify bond conditions. Okay, here we go. Okay, I'm looking at the bond conditions. And it says that the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense in a threatening or harassing manner. But I also see that the defendant shall not go near. And I think we put that in there because there's some type of communication that they're allowed to have through the divorce. Is that correct? I think there was some type of,
That out.
yeah, some kind of app or something.
Yes, Your Honor.
Okay,
There's a Family Wizard app that they are currently using.
okay, now, and the other part of the bond condition, the defendant shall not go near any residence, school, or other location frequented by the alleged victim. And I know they have they have 2 children.
Yes,
They
Your
have
Honor.
children who are in school.
Well,
There are
yeah.
times that they have to be at school together.
Well, the alleged victim used your conditions of bond to preclude him from going to school. She took those up to the school and this thing is all about the child custody thing. You know, I can't
Okay,
say it
okay.
enough times.
Well, what we're gonna do, I mean,
This was retaliation by them because he filed charges on her husband, who was sentenced in this court earlier this year. And it's another thing, he's the guy who he filed charges against, is the
Judge,
same one that took that
the fact that
video.
we're getting into like different cases that are
Well,
not.
they're connected, it's all connected. This
Yeah,
is
but
a
I mean-
child custody thing that they've abused your court of bringing this thing in here. He did not threaten the girl.
okay, now, Let's see.
I'd like for you to change your mind and acquit this thing, Judge.
I mean, the court has already made its ruling.
court can undo. You're the judge. You can say.
Okay, well,
you
the
know,
court is not,
really
the
focus.
court has already made its ruling. Okay. So, in reference to, him not going near any residence school.
Yeah. Well,
Now-
now, let him come up there because she brought that order up. and
Okay,
said,
so we're
well,
gonna,
it's
I mean,
supposed
we're
to be
gonna,
excluded.
now we need to, do you have copies of the order from family court?
Not with me in my.
Okay, I'm just saying that we need we need to draft up something that does not interfere with those court orders. And so what I'm saying, well, at least what I'm suggesting is,
Are you asking our assistant court in some language here?
yeah, I mean, we can, the state as well as the defense can agree on one, what type of contact, because we have that divorce decree and I think, temporary orders out there that allows him to have access to the children.
And in regards to like his inability to go certain places, language that we could possibly put in is outside of appearances that are necessary or customary in the raising of children.
Okay. Okay, so what we need to do is, do you have any objections to that language that he just said? Unless you want to repeat it.
Necessary or customary in the raising of his children.
That he shall not have contact with the victim other than.
Not frequent places. This is we're talking about the frequent places.
Yeah, the frequent placement, what the part in this order that says the defendant shall not go near any residence, school, or other location frequented by the alleged victim. And then he was gonna add some language. What was that language?
See,
Unless it's necessary.
necessary and customary in the raising of children, but maybe it'd be better to necessary and customary for in the exercising of his rights under the custody arrangement or something of that nature.
Okay, now we need to have something more specific so that, let's do this here. So what we're going to do, we're just gonna take a few minutes and draft up some language and see if the parties, if that will,
Your Honor, we have someone here from probation that may have a suggestion
Okay.
as to a workable solution.
okay, Mr. Gilliam is a probation officer.
I'm completely familiar with the case, but one thing, leave the wording as is, but then at the end, but without prior approval of probation. Then you can come explain what this is gonna be, and we can approve the contact.
But will it be in writing? Because,
We would have to.
because he would have to have something in writing, because if they go back to the school will be looking at an order prohibiting from, so he has to have something in it.
You need it on the original.
Right, we need it on the original probation order. Because that would trump the bond conditions, because once he would, after the day, he would no longer be on bond conditions. And so those bond conditions would not be in effect. Okay, so you need a minute to,
Yeah.
okay, then what we're gonna do, just have a seat. We're gonna work on the language for that portion. Now, let's see. Just wait, we'll be in recess on this. We'll come back to it. Okay. Court is back in session in cause number 23 CCCR 1888, case of style, State of Texas versus Ryan Paul Barrett. And court previously announced that the court was placing Mr. Barrett on probation. It's 30 days probated for a period of 1 year. $300 fine plus court costs. Now, the court is going to, in this case, we have community service. So the community service in this case will be 60 hours of community service. He cannot have, well, we get to that later. We have a curfew from 10 p.m. to 6 a.m. and we have no contact with Dalen Thornton, that is, the defendant shall not commit, well, do you have the full no contact or just the second half?
Just the addition, I believe the court has a provision that he not have contact with the defendant.
In a threatening or communications with her in a threatening or harassing manner.
And I would
Correct.
suggest that we add to that
Okay,
the provision that says this order shall not prevent contact or the frequenting of places as is usual and customary in child rearing and consistent with any custody order entered by a family court.
and that's agreed upon by the state,
Yeah, just looking at the language, I have no reason to disagree.
and probation.
Yes, sir.
Okay, so, okay, I'm gonna need a copy of that, but she'll need a copy of that so she can,
It has to be on the
it's gonna,
judgment.
it's gonna be on the judgment. Right, because that's the court order.
Your Honor, I would also request that the court waives the curfew. This man, the report indicated he's not into alcohol or drugs. He is a Little League coach and they frequently go to tournaments and which would require him to be out after the time the court presented. My former background, I was a PSI officer here for Jefferson County, did probation work here for 11 and a half years. I have a master's degree in social rehabilitation. This man does not need a curfew. And I would ask that the court recognize that. This thing has nothing to do with being out late at night or carousing around. He's a responsible man. He's on the Little League board for
Okay,
the Groves.
I
Little League.
understand. Now, what I can do, I think I'm gonna leave the curfew, but we can put some additional language on that because the probation officer can approve him going to the various activities. And so let's see, what was the standard language? Except for employment purposes. Now, the language, the standard language is defendant be inside his home every day. Looking in the PSI, I didn't see anything. Did it have anything about baseball?
Yeah, I don't know that.
It missed that. I didn't see that in here. That
He
he
may
was,
not have come up and I'm just.
Yeah, I know.
I'm just letting the court know that he's.
Okay.
Active, he's got children in sports. We would want to encourage him to do things like that, be a coach, contributing to the community in a very meaningful way. And curfew is going to hinder his ability to do that. I asked the court would waive it. What does probation officers think about it?
I wasn't here for the trial.
no, I'm just saying that.
They're asking about a curfew.
It's not, this isn't the
It's the state's position that it's a same condition, it's an appropriate condition for this case.
Because I think the probation department can approve him going to various functions. I get stuff from the probation department every time. He would just have to keep his probation officer informed. And then that would be the best way to do it. I don't think we're gonna just remove the curfew.
Well, I would ask the court to do that. It serves no purpose in this case, and unless the court is just wanting to be punitive to this man.
Well, it's not being punitive. These are just some conditions. Now it says, it's gonna say, be inside your home every day between 10 p.m. and 6 a.m. except for employment purposes. Now, if there's some other purposes, then he can, the probation office can approve him being outside during the curfew hours. Okay, so we're gonna keep the standard language in. Okay, now let's see, and he will also be required to adhere to the other standard terms and conditions of his probation. So this is the order of court. Just have a seat. The court coordinator would have to draft up the conditions of probation. And once those the probation are drafted up, then we'll be able to sign.
Be safe, be well, sleep sweet, and much love.